Thank you.
Yeah.
All right, let's begin, please. Good morning.
Good morning, Your Honor. I'm Constance Vecchione, representing Bar Counsel. This matter comes before the court on an action filed by Bar Counsel in the Supreme Judicial Court for Suffolk County, seeking declaratory relief and seeking declaratory judgment and injunctive relief pursuant to the Declaratory Judgment Act.
We should change the title, right? Bar Counsel versus Farber?
Yes, and I corrected that in my reply brief. That is Bar Counsel versus Farber. It's not matter of Farber.
But there is a bar discipline action pending, is there not, in which Bar Counsel says that Mr. Farber violates the code by bringing the lawsuit against Damon? So no matter how this is styled, this in fact affects an underlying pre-existing disciplinary action, yes?
I opened a file on the matter and have done nothing with it, pending the decision by this court either to proceed on the declaratory judgment or not. If this matter is resolved by the declaratory judgment, then Mr. Farber, as I expect he would, if it's resolved in favor of Bar Counsel and Mr. Farber, as I expect he would, complies with the decision of this court, we would not expect to go forward on the bar discipline case. If the court decides that there is no standing to pursue this matter by declaratory judgment, then we would be left to pursue it by disciplinary action. But our preferred method would be to go forward on this with a declaratory judgment. We think that this is suitable for decision by declaratory judgment, and I'm looking here to the case of District Attorney for Suffolk County versus Watson, that this is a case, not only is there clearly an actual controversy between the parties, but this is a case that affects much more than the two parties here. It affects the whole bar discipline system. If Mr. Farber is correct in his argument as to the application of SJC Rule 401, Section 9, it would have a severe and drastic effect on the ability of Bar Counsel to put testimony in at hearings and the ability of the hearing committees and the board to make fair judgments based on all the evidence. So we think that this is a case like the Suffolk County DA case that has implications beyond the two parties here, that it would, deciding it would relieve us of uncertainty as to our obligations under this rule, and that it's generally suitable for declaratory relief. But the disciplinary case, there is a file open. Nothing has been done on it. It's just an investigative file. No petition for discipline is contemplated at this point, and we're waiting to see what this court does with this case first. With that in mind, Mr. Farber makes two main arguments. First, he argues that since disciplinary proceedings are, let me back up 1 second and say that what's an issue here is a rule of this court, SJC Rule 401, Section 9, and therefore it's particularly suitable, and only this court can tell us what was intended and what its purpose was. Mr. Farber makes two arguments as to why he should be allowed to pursue a civil action against a complainant who filed a complaint against him and whose complaint went to hearing and resulted in disciplinary action. Subsequent to that, he filed a civil suit in Barnstable County, and it's his right to pursue against this complainant, and it's his right to pursue this action that's at issue here. He makes two main arguments. First, he's arguing that disciplinary hearings are definitionally public after the petition is served, and that for that reason, the admission of a complaint into evidence and testimony at a hearing constitutes a public disclosure within the exceptions in Section 9 to both the immunity provisions for filing complaints, that's paragraph 1, and for giving testimony, which is paragraph 2. And second, he claims that although the rule immunizes testimony before the Board of Bar Overseers itself, it does not specifically reference hearing committees, and thus that any complaints or communications put into evidence at a disciplinary hearing before a hearing committee and testimony before hearing committees by complainants or witnesses are fair game for civil suit by an unhappy respondent, even as here, one who did not prevail in the underlying disciplinary proceedings. As to paragraph 1, and apart from Mr. Farber's broader claims about the meaning of the word public disclosure and board that apply as well to both sections, as to paragraph 1, he appears to be arguing that if the complaint gets put into evidence, then the complainant is subject to civil suit, even though definitionally it would not be the complainant to put the complaint into evidence. Definitionally, the complaint is either going to be offered into evidence by bar counsel, if it is offered into evidence, or it could be offered into argument by a respondent who wishes to cross-examine the complainant as to, looking for inconsistent statements as to the content of a complaint. It could not be that this was this court's intent, that when one of the parties, bar counsel or the respondent, puts a complaint into evidence, that the complainant under paragraph 1 is then subject to civil suit. So that's Mr. Farber's first argument. As to paragraph 2, by its language, it protects and provides immunity for testimony during any proceedings under this rule, meaning Rule 401, which covers all aspects of the disciplinary process, most certainly including hearings.
No, the AB, if I'm remembering this correctly, the ABA rule actually specifically mentions hearing committees.
That is correct.
Our rule doesn't. Is there any significance to that?
In the context of this rule, the word board has to be read to include hearing committees. First of all, again, I'm looking to the case that this court decided a couple of years ago, Halibian versus Berb. Any other decision would create an absurd result if we intended to say that the immunity protections stop at the hearing room door. But beyond that, hearing committees are an arm of the board. They're appointed by the board. Motions during the course of a disciplinary hearing are filed, all pleadings are filed with the board, including motions after the hearing committee is appointed. Some motions can only be decided by the board chair or another member of the board. Board staff assist at the hearings and often assist in writing the hearing reports. In the context of this rule, to preclude hearing committees from the definition of board would not make any sense.
Can I just ask you, though, what does the phrase that provided, however, that such immunity from suit shall apply only to communications to the board or the bar council, communications to the board or the bar council, and shall not apply to public disclosure of information contained in or relating to the complaint? What does that last clause refer to?
Which part of it, Your Honor?
That immunity is not going to apply to a public disclosure of information contained in or relating to the complaint.
The intent
What
of
was
that
intended to do?
The intent of that is made, if you look at volume 9 of the Mass Attorney Discipline Reports, the preface to it contains an introduction from the board, written by the board's general counsel, Michael Frederickson, and a letter that Mr. Frederickson sent to the SJC Rules Committee at the time. And in both of those documents, Mr. Frederickson and the board make it clear that what they were attempting to do was to address concerns by bar associations that the immunity provisions included public disclosure to a newspaper or nowadays we would say blogging about a complaint. What they intended by that rule is to protect, and the introduction says this, that the rule is intended to protect those who file complaints with the boards and who testify at its hearings. That's the language of the introduction to the rule.
So it would be disclosures by complainants? What about disclosures by people in bar counsel's office to reporters? It doesn't say by whom these public disclosures of information.
Well, but people in bar counsel's office and by the board, first of all, have separate immunity under a separate paragraph of this rule. That's not an issue here. But yes, I mean, we're constrained. I mean, at the point when something is public, what's public is public. The board will release.
Right, but I mean, this is apparently intended to get at things that are not public.
Correct. It's intended to get at things that are not public.
Disclosures that would not be, people who would not be immunized for making disclosures would include the complainant, perhaps anybody else?
Other witnesses.
Other witnesses.
Members of the hearing. You know, well, I mean, the other people are protected. The staff, the hearing committees, the board are protected by other sections of, other paragraphs of Section 9. But what this is intended to get at is that a complainant who goes outside the hearing process and talks to a newspaper or who starts blogging, and I think it's an interesting question that hasn't been reached as to what would be the parameters of what a complainant could be held liable for if he or she just made public to a newspaper what was already public. But that is not the issue before this court now, because there's no allegation that this complainant went to a newspaper or otherwise made anything public here.
But the person, the complainant did go to the Division of Professional Licensure and turn herself in, as it were. Or I don't know if she did that, but she went to the Division of Public Licensure and made a statement to them, didn't she?
Correct, concerning Mr. Farber's broker's license. She filed the same, he filed the same complaint with the Division of Professional Licensure that he filed with the board.
Yeah.
And the Division of Professional Licensure did nothing with it, did not even notify.
But do they have a privilege comparable to ours?
We're not aware of it. As far as we could not find.
So the statement to the Division of Professional Licensure could be the subject of a libel action.
Yes, and we're not, that's outside the parameters of this proceeding, and I think.
The substance could be there, it's just, it cannot be based on what Mr. Damon said or filed with the board, that's your point.
It cannot be based on the fact that he filed the same complaint with the board or that he testified before the board. He's still immune from filing a complaint with the board or for testifying before the board. The only liability he could have, in theory, for filing a complaint with the Division of Professional Licensure if there's no immunity that applies there, no common law immunity such as in Fisher versus Lint or otherwise. And I think that there would be an anti-SLAPP motion that probably would be possible, but that's neither here nor there either. But the only liability that would flow would be for damages arising from the complaint to the Division of Professional Licensure, not from any damages arising from the complaint to the Board of Bar Overseers or the testimony at the bar discipline hearing.
Well, could I go back to the first part? So once, when, if I understand the facts correctly, that there is a hearing, and after the hearing committee makes its recommendation, first of all, that's open, right?
Correct.
And then after the hearing committee makes its recommendation, if I understood correctly, Bar Counsel or the Office of Bar Counsel contacted the newspapers? No.
I mean, that was denied. And is not relevant here, but we don't know how the matter got to the newspaper after the hearing. After the SJC decision by the single justice, the board would have notified newspapers. It does that as a matter of course.
Okay.
As to the hearing, if a newspaper reporter or anyone else requests a copy of the hearing report, the board will provide it. It is public. The board does not, as a matter of policy, automatically release hearing reports or board decisions unless they're the final decision. It's only after there's a final decision in a public matter that the board, as a matter of course, notifies local newspapers, Lawyers Weekly, puts it on our website.
So what this last clause of paragraph 1 means is that such immunity from suit for the complainant shall apply only to communications to the board and shall not apply to the complainant's public disclosure of information contained.
Or any other witnesses.
Or yeah.
Correct. That's correct.
Where it's focusing on the removal of it's on immunity, and it's the removal of immunity by actions taken by the person who would otherwise be immune.
Correct. By the person who would otherwise be the object of the civil suit, and it would remove immunity if that person went to the newspapers or started blogging or something of that sort.
But they don't forfeit immunity for the statements that they made to Bar Counsel or to the board.
That would be my argument.
Not us to say that.
That would be my argument, yes, that they would not forfeit immunity for that.
So you are encouraging us to issue a declaratory judgment to the effect that a complainant or a witness who makes a statement to Bar Counsel or to a hearing committee or to the board in the course of bar discipline proceedings is entitled to immunity for such statements.
Correct. And that the words public disclosure were intended to mean disclosure outside the confines of the disciplinary process, and that hearing committee was intended to encompass the board, and the board is intended to encompass the board's hearing committees. And to just address one further question that Mr. Farber raised in his brief, that the liability, the civil liability includes all forms of torts, not just libel or slander, but also malicious prosecution and any other such claims.
Let me ask one more question, because I'm not sure I understand how this works. Are you saying that if the complainant or the witness, whatever they testified to before, within the confines of the board discipline process, if they then go out and blog and say, this is what I just said at the disciplinary hearing, and repeats those statements accurately, what are you saying about that?
I say that that's a good question, Your Honor, but I don't think it's the question raised by this case.
I take it they would not be immune.
I think that's arguably true, Your Honor. You know, what the liability would be if all you did was repeat something that's in the public record is a good question, but it's not the question that's raised by this case, and it's not a question that I think the Office of Bar Counsel or the Board of Bar Overseers
No, but it's useful in trying to figure out what this language means.
I agree with you. I think that what the language means is I think if you look at what the board wrote in its introduction and in that letter to the SJC Rules Committee, they say that it's modeled on the ABA rule. They do not use the same language, but they say it's modeled on that, and I think that was what was intended, exactly what the ABA rule, model rule says. Thank you very much.
Thank you.
May it please the court, my name is Peter Farber, and obviously I'm the respondent in this case. And I appreciate the court taking this case on, and I think the rule as it's written is subject to interpretation. I'll be very frank with the members of the court. When I was contemplating after all the newspaper articles came out, and I was contacted and by one of the reporters, which is in my brief, I think I knew I had to make a decision, and I knew, although obviously I have much authority against me at the hearing committee, and the board did not upset the findings, was that Mr. Damon did lie, that we never had this meeting in my office where he said that I was going to buy the property with my brother and we were going to renovate it, and I would give him an exclusive listing. And what aggravated me about that is that I had already had many conversations with him when he did learn who the true buyer of the property was, Miss Garrity and her now husband, Dr. Johnson, that in all cases he was saying, she was my customer, she was my customer, you took my customer. And I kept saying, no, I did not take your customer. And she was never going to purchase from you. She didn't even like the property when you showed it to her. And she didn't like you. And it was only when Dr. Johnson became involved and he began looking at it in a different perspective. And then I even encouraged him, Mr. Damon, to call Dr. Garrity and speak to him directly, which he did. And Dr. Garrity confirmed what I had said. It was then that his story changed, and then that he concocted this new story that he put into his complaint and filed with Bar Counsel. And obviously, because I was a lawyer, he saw some new avenue of relief to try to get his $13,000 back. I mean, normally he would have filed a complaint in the district court. It's a claim under $25,000, and there would have been a hearing, and there would have been evidence taken, and the judge or jury would have made the decision. But he kind of upped the ante. He had an ulterior purpose. He says, oh, this guy's a lawyer, too. And so he was using the bar discipline proceedings to try to win his case and use the Commonwealth to accomplish his end. And that's what this became. And he was successful, not in getting his $13,000 back, but certainly on the first go-around he would have been successful. And my problem all along was that none of the evidence that I sought to get across during the confidential part of the proceedings, during the investigative part of the proceedings, no one would listen, and no one would speak to the witnesses that I said should be spoken of. And it continued right on through until the hearing committee, and I mean, the people who were accompanying me, we could all feel the chill in that room the minute the hearing opened. The point is I know we're back to Rule 9, or Section 9 of Rule 4.01. And when I decided to file the suit, the Assistant Bar Counsel immediately contacted me and said, you must dismiss the suit. Mr. Damon is immune. And I tell you the truth, I was not familiar with Section 9. So I read it, and I read it, and I read it. And then I wrote to Mr. Frederickson and said, I don't see where this applies. And that began a conversation between Ms. Vecchione and myself. And I kept hearing, well, the Lupo case controls. But I didn't find that to be the same case. And then when I began to look elsewhere in other states, of course, I found a multitude of rules. Many of the states still do confidential proceedings throughout. Some have rules of absolute immunity, and some do not. And so then I went to the...
Excuse me, when you say absolute immunity, including for malicious abuse of process or malicious prosecution?
Well, some are for all forms
everything.
of civil proceeding.
Yeah.
Some are, for instance, Connecticut just adopted a rule that is absolute immunity for claims of defamation, but not as to malicious prosecution. And then I went to the attorney discipline reports, and they're attached. Ms. Vecchione referred to them in her presentation, that were published in 1993 when the rule changed. And again, what I read there did not seem to support what Bar Counsel was telling me. Mr. Frederickson, who obviously there was a proposed rule change, it then went out for public comment, and apparently several of the bar organizations didn't like the wording, didn't like this absolute immunity. Now, I've never seen the original rule and the language of the rule. I only have what's here now, excuse me. But Mr. Frederickson says, in order to clarify, and I'm reading from Roman numeral 22 in Addendum B, which is his letter to the Rules Committee, in order to clarify the scope of the immunity suggested, the board proposes adding a proviso that immunity would extend, and I quote, only to communications to the board and the Bar Counsel, and shall not apply to public disclosure of information contained in or relating to the complaint, end quote. And that, of course, became the rule. And then I review the rule, and I see that the board is a very specific entity, and every time in the rule throughout, when there's a reference to the board, it's the board. When there's a reference to Bar Counsel, it's to the Bar Counsel. And hearing committees are referenced often, but never as sort of conglomeration with the others. And so I read it, and maybe I was wrong, to mean they have, in this term public disclosure, they have drawn a line in the sand, something that the bar associations apparently desired, and that during the confidential part of the proceedings, then the rules of immunity, absolute immunity, would apply. But once the charging decision was made, it seemed that new rules apply. I mean, that's what the rule said to me. And it seems legitimate and reasonable to me. It doesn't seem absurd. And I couldn't see any way to differentiate different types of public disclosure. I mean, in today's world, public disclosure can happen in a millisecond and goes everywhere. And so, granted, in 1993, that probably didn't exist. But clearly, it seems to be that the line that was drawn was between the time when the proceedings are confidential, because then the lawyer can suffer no harm to his reputation. And once they become public, it's a different rule. That's how I read it. Possibly I was wrong.
Mr. Farber, just to play that out, if the first part, I'm looking at 9.1, if the complainant is immune from civil liability based on the complaint, and the complaint is filed, and proceedings go forward, and bar counsel prosecutes that complaint, and at that point it becomes public, then the immunity, in your view, through nothing that the complainant did, has gone away, right?
Well, I would say...
Bar counsel decides to proceed with the case, and it goes to a public hearing. As I understand your argument, that is the end of immunity. And there's nothing that the complainant did to bring about the end of that immunity.
No, nothing the complainant did other than in initiating the...
So it's like having no immunity at all for any worthwhile complaint. Right?
Well, see, that's the hard thing, because we're going to have worthwhile complaints, and certainly...
One that goes forward, that's all I mean.
Right.
One that goes forward.
I guess I could best answer your question by saying that the whole investigative process is to sift out the wheat from the chaff, to learn whether the statements that are being made in the complaint have some legitimacy. And based on what my experience was, these were not vetted properly in this case.
That's a problem of bar counsels, not of the complainant.
I understand. If it happens to me, though, it may be happening to others, and I obviously don't know. But it would seem to me, and I agree, we have to somehow make this work, that when the charging decision is made, it's because all of the statements in the complaint have been vetted. All of the contrary information has been absorbed, taken in, and then the decision is made. It would seem to me at that point that the bar counsel would notify the complaining witness, we are going to go forward on this complaint. Under our rules, you will lose whatever immunity you had when these proceedings remain confidential. Are you sure that what you said in your complaint is true? I mean, maybe that system wouldn't work.
An incredible disincentive to file complaints. I mean,
But it would give one pause. It would have given Mr. Damon pause, because he wouldn't have known what would happen at the hearing committee. He wouldn't have known whether he would be made to look like a liar, that the hearing committee would say, sir, your first statement and your second statement are contradictory. And why would Mr. Farber, when he was with the offer to purchase and the purchase and sale agreement and the listing agreement all say that the commission is split, why would he come up with this story about having to give you an exclusive listing at some point in the future? And so he would understand, a reasonable person would understand that there's some risk on their part if they're lying. To me, that's a reasonable rule. I mean, isn't that what we tell our children? That you don't lie because you might get caught in your lie.
And so the risk is the civil suit.
Pardon me?
The risk is the civil suit.
The risk would be, well, it would be dismissal of the complaint.
Well,
at
it
the
didn't
first,
happen here, right?
And then it could be a
you're
civil
saying that
suit.
it went through the hearing committee, and the hearing committee found against you.
They
So you're
did.
saying that the only risk wasn't at the hearing committee level, there wasn't a risk to Mr. Damon then. You're saying the risk to Mr. Damon is that you can then follow up on an adverse hearing committee result with a civil lawsuit.
That would be the risk. Certainly that would be what he would be. And I would suggest that Bar Counsel would inform him of that possibility, or of course, any complaining
Of course,
witness.
a suit can be brought, whether or not, I mean, there's no, someone in your situation doesn't say, oh, you know, Mr. Damon's right, so I'm not going to bring a suit. I mean, somebody could bring a suit, anybody could bring a
I
suit
know.
regardless.
Justice Botsford, I've read many cases, and over again, I hear courts saying, we must, I'll paraphrase, sacrifice the lawyer's reputation, because the greater good here is that we get all complaints, even those that are false and malicious. And I understand. It just seems to me that that's where the investigative process comes in. That's the balancing that should occur. And what did this court, of course not this court, but the court, the members that preceded you, what did they have in mind when they adopted this rule? Maybe it's what I'm saying, maybe not. And I think that, of course, is your job today. But I thank you for all your time, and if I can answer any other questions, I will, but otherwise, thank you.
Thank you very much, sir.
Okay.